Hello and a warm welcome to you all. We recognize there are many places that you can be right now, and so we're incredibly grateful that you've chosen to share these next 90 minutes with us to grow in shared understanding of fair housing. We'll get started in a moment, but my name is Catherine Daria, and I am co-moderating this session with Jody Weiner from the Sacramento Steps Forward team. And as you're starting to come through, today we are set for an insightful and engaging session with our local partners here and passionate staff. And before we begin, just a few reminders for us today. This webinar is closed captioned for accessibility, and we're also recording this session. So you'll receive an email with training materials that you can revisit at any time. And as we allow more folks to get into this webinar, please use the chat function below to drop in your agency name and the area that you serve. The questions that you're submitting through this webinar are definitely highly encouraged. And so we'll be responding to those as we go. And after today's presentations, we will be elevating any unanswered questions for our speakers. Also, to limit background noise and other intended disruptions, all participants will be muted during the presentations, but do reach out to us in chat with any technical issues. All right. We are expecting a few hundred folks for this training, but with that said, let's get to know it about each other and take a moment to answer this first poll for the day. All right, this first poll should be up on your screen. Just tell us about yourself, who you're joining and representing. And for our presenters, that follow-up question is to gauge how much you know, how you're coming into this presentation, and where we'll be focusing on for today. All right, today's learning experience is crafted to deepen your understanding and provide insights into fair housing and discrimination so that you leave feeling knowledgeable and resourced with actionable next steps for your clients. At the conclusion, we hope that you can complete an exit survey. Your feedback is crucial for us to enhance future learning experiences. And Jody, if you wouldn't mind, please sharing our results. Okay, it looks like we have quite a variety of representation on this call. Most of us are coming from CBOs, community-based organizations, a few healthcare systems represented, frontline staff, advocates, and general public. So welcome. Thank you for joining us here. There's also quite a variety of knowledge going into this training, and so I'll mention that this session is intended to be more introductory or a refresher for those who are familiar about fair housing, the fair housing sphere. So today we will begin with a quick background on the relationship between discrimination and homelessness and how the community is working to address these challenges. We will welcome our partners from Project Sentinel and Legal Services of Northern California, who will be presenting more information about the protected categories, reasonable accommodations, supporting justice-impacted clients, landlord and tenant relationships and responsibilities, rent control protections, and more. And finally, as mentioned earlier, we will be ending with a Q&A session and a few reminders. Okay, so if you are new to Sacramento Steps Forward, we welcome you. To start, SSF's vision is to have an equitable community where everyone has a safe place to call home. We are the lead agency for the Sacramento Continuum of Care, or the COC, which is the regional planning body for our homeless response system. And part of our work here is to strengthen our community's capacity to address homeless response challenges and to develop and communicate and maintain these system best practices. So this involves partnering with and convening key stakeholders like you to coordinate service delivery and administer the homeless management information system, or the HMIS. While this training is directed towards our COC providers funded through HUD, we do invite the broader community in skill building and resource sharing. So the upcoming presentations will be covering laws and protections for families and individuals to ensure that we're not unnecessarily harming and contributing further to the compounding trauma for the people that we serve. So to start, we define discrimination as an individual being treated differently from others based on characteristics such as race, sexual orientation, gender, physical disability, citizenship status, and more, as you see here on the screen. And research shows that people who occupy multiple marginalized statuses are at higher risk for discrimination. These increasing intersectionalities layer into the compounding trauma. And so it's important for us all to, as providers, advocates, and allies, it's important for us to be armed with policy knowledge and tools so we can empower our clients when seeking and maintaining housing. Again, the increased likelihood of intersectionality and discrimination is correlated to forcing people to live in dangerous and undesirable environments. And this is the essence of why we are here doing the work we get to do in the community. And so as we discuss these fair housing basics, we'll be covering these examples of impacted marginalized communities. And the first example here is the LGBT community, who face stigma and discrimination throughout their life and are more likely to face affordable housing challenges. They're less likely to own homes and more likely to become homeless. So what we see is a recurring pattern of discrimination that leads to homelessness, and this increased and our varied experiences of homelessness in turn lead to additional discrimination. And in recognizing and addressing these cyclical damage and trauma within the intersection of discrimination and homelessness, can lead to it can lead us to improved health outcomes and better quality of life. And very briefly, we can see that the 60s and the 80s were critical for fair housing as California enacted prohibition of housing discrimination, soon followed by congressional support against illegal discrimination, and later on with added protections for people with disabilities and for families. Our partners will go into more depth on these laws soon. All right, so originating from the Local Homeless Action Plan, or the LHAP, is the new Regional Coordinated Action Plan, being called RCHAP. This RCHAP was informed by several workshops held late last year and actually adopted a few weeks ago by several bodies, including the Sacramento COC, Sac County Board of Supervisors, and the City of Sacramento. Yes, share this excitement, use those reactions. We appreciate it. All this great work is happening within the community, and really wanting to highlight that collaborative effort. And so this plan acknowledges that discrimination continues to be a barrier to housing for many people who identify with historically under-resourced communities. And stemming from this work to help keep us all accountable is a set of service standards for our community and standard learning programs. So more on that over the coming months. Affordable housing is a major contributor to homelessness here in Sacramento. And so through cross-sector collaboration, we can coordinate funding to increase housing opportunities, such as ongoing rental assistance, permanent supportive housing, and navigation. You can learn more about the RCHAP on our website. And in reference to collective action that's just been mentioned, here are a few usable resources for fair housing, including state and local supports. You will get a copy of these slides for future reference, so no need to make notes of these numbers or links. Those will follow. Today, we are pleased to have Project Sentinel and Legal Service of Northern California to share about their work and the human rights protections for the clients that they serve. Okay, so today we are very excited to be joined by Avantika Rao and Jorge Iniguez. First off, we have Avantika Rao, who has worked as a solo practitioner in Sacramento and also worked at legal aid programs focused on immigration, employment, and housing. She's currently with Project Sentinel handling housing and urban development and civil rights department filing and dispute resolution across various Northern California jurisdictions. She has been recognized by the Lawyers Committee for Civil Rights for collaborative legal and press strategy for human trafficking survivors. So we'll hear first from Avantika today. We'll have a 5-minute break and then hear from Jorge next. With that said, Avantika, the mic is yours.
Thank you so much, Nika, and I really want to welcome every one of you. You are in the field working with populations that are in dire need, and especially post-pandemic, now that a lot of the supports that were temporary have been starting to go away, you're seeing a lot. And I want to just recognize that. I've worked as what I call as a legal first responder for quite a while. So let me start with a little bit of an overview of myself and then the organization that I work with. And we're going to go over protected categories. We're going to go over reasonable accommodations and then a couple of other topics. So myself, I'm she, her, hers, Avantika Rao, Fair Housing Staff Attorney. And this is our fair housing overview with Project Sentinel. Next slide. So I'm licensed in California. I am fluent in Spanish. I'm also proficient in Hindi, which is spoken by members of the Indo-Pakistani diaspora. And I initiated a landmark trafficking case, specifically a labor trafficking case, US versus Dan, and argued at the Ninth Circuit as well on an asylum case. Next slide. Just to say, this is general information in this presentation, and specific advice is best obtained on a case-by-case basis. Laws and policies are constantly changing. In terms of what we're going to cover a little bit about Project Sentinel, an overview of protected classes, an intro to disability accommodations, and then we're going to touch on criminal records, LGBTQ plus, and crime survivors, and then retaliation. Next slide. So just to sum up, we're a nonprofit. Project Sentinel is a nonprofit that assists both landlords and tenants. We have 3 departments: dispute resolution, housing counseling, and fair housing discrimination, which is the last division is the one that I work with. Our fair housing discrimination department investigates claims of discrimination, also assists people with requesting reasonable accommodations, and follows up with filing complaints with the California state agency responsible for civil rights in cases where we find we can escalate it to them. Next slide. Our service areas are several counties, including Sacramento County, and then several cities with large populations. We also have federal funding from the Housing and Urban Development, so that's helpful for us to cover quite a lot of areas. Next slide, please. So in general, what we do in terms of actions is we do testing of housing providers. Testing meaning sending out people who are in a protected class as well as a non-protected tester to see whether there's discrimination in various housing providers. We educate, we investigate based on people bringing forward complaints to us. We negotiate and we advocate. At this point, I'd like to ask if you could share in the chat, what do you believe is a protected category for fair housing purposes in California? Seniors, members with disabilities, race, gender, sexual orientation, race, LGBTQ. Yes. Do any of you have some knowledge of what is a protected category in California? Age, disability, race, ethnicity, religion, all individuals, age, disabilities, race, gender, VAWA, race, national origin. Very interesting. Okay. Queer and trans, and then race, religion, DV, gender, marital status. Okay, next slide, please. Thank you. So here's an overview of, and there's two basic laws, levels of law. There's the federal level, and then there's also the California level. So what's really important for all of you who are in the field is that we have broader protections in the state of California than at the federal level. The federal level is kind of the floor, and California has actually a broader set. So on the federal level, we have on the left, we have race or color, national origin, religion, sex, sexual orientation, and gender identity, disability, and familial status. As Nika mentioned in the beginning, familial status and disability were later amended to add into the Fair Housing Act. Now we'll move over to I'll just mention, and we'll cover this a little bit later, that sexual orientation and gender identity were recently affirmed to be protected categories by the Biden administration's HUD. So moving over to the right side where it says California, you'll see marital status, age, source of income, arbitrary category or military veteran, immigration status, primary language, and licensed daycare providers. Next slide, please. This is a basic tip for all the people who are working with tenants in the field or people who are in danger of being denied housing or being discriminated against, is just if you're working with people and interfacing with them and they're dealing with text messages, please download, save all of those text messages or emails from the apps, screenshot them, save them in PDF form, always keep copies or advise them to keep a separate file of all those documents so that if and when they ever need to interface with a legal advocate, they already have a file and those things have not been deleted from the apps. Document. If you're denied from housing, request a proof of that, which would be a denial letter. And especially it's important to figure out why they're being denied, if it's at all possible. We've gotten everything from video proof to text messages to screenshots of rental, Zillow rental manager, all sorts of proof. Next slide. Disability. So there's three main bullet points here. A physical or mental impairment limiting a major life activity, a record of impairment, or being perceived as having such an impairment. Let's see. And I'll just say that there's, in terms of major life activities, these can be anything from breathing, speaking, eating, caring for oneself, thinking, processing information, remembering. It can also be physical things like ambulating or moving or walking. climbing stairs, moving from a laying down position to an upright position, seeing, hearing, all of these things can be potential major life activities. Next slide, please. So here we have a poll. What percentage of the population you serve has one or more disabling conditions that may require a request to a housing provider? And if you finish that poll, you can also share in the chat what types of disabling conditions the families you serve have been living with. So it's pretty evenly distributed. But about 22% say 0 to 30, about 38% say 31 to 60, and about 40%, which is actually the largest, are saying 61 to 100%. So quite a large proportion live with various, and in the chat, I'm seeing various disabling conditions such as PTSD, mental disabilities. I think I saw developmental up top, mental, physical, serious mental illness, aging, mobility, mental health with dual diagnosis, mental, physical, bipolar, AOD, mental health, HIV, AIDS, AOD, mobility issues, mental health, COPD, a family with a child who's autistic. Alcohol or drug. Oh, okay, thank you. Yeah, if you could spell out the acronyms, that would be helpful, and we'll try to do the same on our end so that we can all be understood. All of the above: mental, physical, alcohol or drug. ADL, could you spell that out? IADL. Activities of daily living. Okay. Okay, I think that completes that. Oh, combat post-traumatic stress disorder, COPD, which is chronic obstructive pulmonary disease. Yes. Have any of you run into long COVID? We have at Project Sentinel, and just wanted to alert you that that's coming if you haven't. Okay. Okay, so we'll move to reasonable accommodation. Just to give you a little bit of a flavor for what to look for, is that when you're in the field and you're encountering all sorts of folks, and some of them are living with disabling conditions, and like Nika was saying, it's all intersectional. So it's kind of coming to you all together. You kind of have to untease which aspects might require a reasonable accommodation. That's a term that, if you haven't heard, it just means an exception. So we're asking for a disability related exception to a policy or a rule or practice or a service. That basis is the Fair Housing Act. In California, it's the Fair Employment and Housing Act and the implementing regulations. But basically, if you're ever talking to somebody in the field, you can just say, we can ask for an exception for you. Please give us some documentation about the nature of your disability. And I'm going to go into a little bit more detail about what documentation we can provide, we can request. this, I just like to go over the bottom of the slide because I wanted to keep in there that it's for equal opportunity to housing. It's really important. I think intersectionality is an absolutely critical lens to use when we are service providers interfacing with people, because in our minds, we have to have this roadmap as a responder, as a service provider, that all of these things are happening intersectionally and can happen at the same, to one individual or a family at a kind of systemic, and also it can be an implicit bias level. And the reason why we have these protections in the law is that if we don't identify, if we don't seek these requests and make an exception for this person, they will not have equal opportunity to enjoy their property that they're using or living in or applying for at the same way, in the same way that a non-disabled person will. Next slide, please. Example, sorry that it looks like it kind of shrunk on the left side. I'm very sorry about that. But it was service animals. I wanted to give some examples of exceptions or reasonable accommodations that we can request. Service animals for people who need them as a result of their disability. Emotional support animals, which are protected in California. Transfer of units, now protected in terms of California law in certain cases. Extensions of time. Just want to note for extensions of time that it's usually they have to continue paying rent. On the right, we have break of lease, rental due date, caretaker or live-in aid, second chances, and accessible parking spaces. Let me kind of explain these. So emotional support animals and service animals could be its own training. There are actually, it's a subspecialization within fair housing law. There are all-day trainings on that topic alone. But basically, they are protected. You do need to just request documentation. The California Civil Rights Department on its website does have helpful handouts about the type of documentation that's required under California law. Basically, they have to have been seen by the clinician for at least 30 days, and it has to be disclosed their license and who they are and things like that. And they have to put a statement that they swear under penalty of perjury that is not false. I still see, and we still get complaints about widespread discrimination by people who, for example, housing providers who say no pets allowed. If you see those types of circumstances, as a housing provider, you can investigate for us and take screenshots or save PDF files of the advertisement saying no pets allowed, and then also the email trail with them when you apply, when the person applies. And what I would suggest is actually do not disclose upfront that you have an emotional support animal or service animal. Just apply, and then when the person is there after they've moved in, then show the documentation. Now this is if they are verified, right? And the reason I'm saying this is because there's still widespread gamesmanship in terms of the ways that discrimination plays out. So transfer of units, now under California law, in certain circumstances, they can request a comparable unit on the first floor of their same apartment complex or building. Extensions of time we covered, as long as they're paying rent. Breaking of the lease, usually they're contractually required to bound to have paid through a certain time, whether it's 1 year or a certain time period, but as a reasonable accommodation exception, we can ask for that to be waived. Rental due date change, we see that where people get paid by Social Security or some other source of income on a certain date, and that's different from the date in their rental contract. We can ask for an exception. Caretaker or live-in aid is probably something you've seen, I would imagine, in the housing populations that you're working with. But people often need somebody to live with them to help them with the activities of daily living. And we just help with documenting that process. Second chances, that's a little of a term of art, but second chances is like housing providers and property management are often tasked with kind of keeping quote unquote problem tenants documented and then escalating that to eviction, kicking them out eventually. We can sometimes, quite frequently, the ways that they single out tenants as quote unquote problem tenants and document them are often discriminatory. And so if you can get written documentation about that, we can investigate that as a fair housing claim. We can often try to negotiate or educate them about the law and see if we can work out a resolution. We actually did that with an autistic adult in a family in Sacramento County. Just to add specificity, they had a physical assault on another child in the facility, but because they were developmentally delayed, they it was kind of understandable actually, because as they were post-pandemic really delayed by some of the lack of access to their behavioral supports and practices. So we were able to prevent their housing loss. And accessible parking spaces is if they need it as a result of their disability. There are some specific questions popping up in the chat, and I just wanted to say, if you could ask those in the Q&A towards the end of the presentation. Thanks. Next slide, please. Denying a reasonable accommodation. So a reasonable accommodation is the request for an exception by the applicant or the person who needs the enjoyment of the housing. On the other hand, the people can oppose the request, and their potential reasons I wanted you to know so that you can weigh those and anticipate those is they can say, the housing provider can say it's an undue administrative or financial burden on their end if it's really expensive or it's really logistically problematic. They can argue that it's a fundamental change to their program, and they can argue that's undue health and safety burden. Next slide. Just to introduce you to the topic, if it's a physical change to the unit, the same exception process is called a reasonable modification. And this can be things like raising or lowering of cabinets, changing of the types of opening mechanisms for cabinets, ramps, or changing of the flooring. I've seen removal of carpet and putting down some sort of laminate or solid flooring. I've seen that for people who have breathing problems or allergies. I've seen requests for installation of noise insulating materials in housing. And then the landlord does have a right to approve the plans for physical modification and ensure a workmanlike product. Next slide. Criminal records. And what percent, well, do any of you see people who have criminal records having problems with housing? Just put yes or no if you see it in your work in the chat. Yes. Okay. Yes. Oh, so we are sharing with you so that you can help us to get out the word that you cannot have blanket bans on all persons with criminal convictions to require that for their housing application. They can, on a case-by-case basis, kind of look at the circumstances of each conviction. It has to be a conviction. It cannot be something that was just an arrest. However, it's not a protected category. So it's not an outright protected category. There is still a lot of housing providers who do ask about felonies or misdemeanors and may have screening out. There are also criminal background databases that they may check on their own. So we would like to just put out the word that Project Sentinel is interested in investigating these types of cases. So if you can help us by documenting it and raising it to us, please let us know if there are those types of discriminations happening, because we are aware that that particularly impacts LGBTQ, Black, Brown, and other communities of color. Next slide, please. Oh, okay. So there's a short poll. What percentage of the population you serve identifies them as LGBTQ+? And Jody, whenever you're ready, if you could share the poll. Thank you. So actually 79% of you said 0 to 30%, 17 said 31 to 60%, and 4% said 61 to 100%. So a wide variety there. Okay. So just an overview, and this is another topic that we could actually go into in another separate training. But as I mentioned, the top, and we're going to do crime survivors next. This LGBTQ plus, I want to be very inclusive that it then includes lots of lesbian, gay, bisexual, trans, queer. It may also include households that live together who are more than, for example, more than a couple. Under Executive Order 13988, federal protections regarding sex discrimination in housing have been expanded to include sexual orientation and gender identity. And the 2012 HUD LGBT rule ensures equality to those based on different sexual orientation, gender identity, or marital status. Marital status is a protected category in California. That applies to all HUD-funded programs, including Section 8 and public housing. Next slide, please. So I'd like you to share in the chat what types of crime survivors you have been serving or have served. So in one sentence, if you could summarize it, I know it may be a lot of different types. And also please share if you're dealing with domestic violence, if it's like elder domestic violence or adolescent domestic violence, or yeah, where do you start? So many types: domestic violence, assaults, sexual assault. I'm sorry, it's hard to read. DV, domestic violence spouse, 290, that must be sex offender. DV, rape, human trafficking, domestic violence spouse. Identity theft, DV, victims of community violence, family violence, yes. Domestic violence, domestic abuse survivors of adult age, physical assault, domestic violence, intimate partner, DV, sexual assault, community and family violence, domestic violence, child adult abuse, identity theft, police brutality, emotional and mental abuse, yes. Emotional and mental abuse seems like a silent epidemic that many populations suffered, especially during the pandemic, because everyone was kind of almost trapped in whatever circumstances they were in. Sex trafficking victims, DV in transitional aged youth. Oh, okay. It's a heavy load that all of you are encountering in your day-to-day work. Okay. Thank you. Okay, we're almost done in terms of times. In dangerous relationships in exchange for shelter. Yes. Trading sex or relationships for shelter. Okay, so just to summarize, a landlord, there are a few protections for crime survivors. This does now have been expanded to include human trafficking survivors, stalking survivors, as well as domestic violence and intimate partner violence, including rape. So just want to summarize that sometimes this can include their right to summon law enforcement and emergency assistance. Sometimes it can include getting the locks changed of a survivor's unit upon provision of proof. And sometimes that can include breaking a lease early. Next slide, please. Familial status, we see that pretty widespread discrimination on this basis. It's the California Government Code 12955.2. I have it up here in my office because we see it so frequently. It's involving discrimination when there's the presence of minors under 18 years old and pregnant women, or it also occurs when you treat families with children or people with children differently. It also includes adopted children. There are also often overly restrictive rules directed at children, prohibiting it's as they treat households with children differently than adult-only households. We just got a complaint about this week, where the landlord said, "Oh, there's a child. We're not going to renew your lease." Occupancy limits. Yes, occupancy limits are sometimes too restrictive. It's rules specifically about children, common areas, and supervision. Next slide, please. Sources of income. Now it's been broadened in California to include all legal and verifiable income sources such as SSI, SSDI, spousal or child support, foster support, Section 8. And also the minimum income requirements should just reflect the tenant portion of the rent if they're a Section 8 or low income person on Section 8. Next slide, please. I just want to say that source of income has become a very big topic, hot topic in California. We do see a lot of discrimination still against Section 8 voucher holders, but it was outlawed a couple of years ago. And now the regulations have been updated to state that the landlords have to sign those paperwork for Section 8 vouchers. Age, just want to summarize that senior properties are allowed to discriminate just on that basis, to keep out people who are of certain younger age based on their rules. But they do have some exceptions for live-ins, caregivers, and spouses. So those can be subject to a reasonable accommodation request. Next slide. This is a sample renter's resume. We can share that with you after the presentation. We recommend this especially in situations where you need to document the name and contact information, the tenant background, employment, rental history, reference, contact information, proof of income for people who have either like criminal records in their history or were in prison and things like that. That really can help document. And I'm helping one individual just get landlord reference letters. That's very helpful. Next slide. Finally, as a separate claim, in addition to the discrimination claims that we kind of went over, there can be a retaliation claim that is protected, and it is protected. They are protected from being harassed, evicted, or any adverse action because of opposing discrimination. Next slide, please. I just want to share that we have some excellent toolkits available for download for free. They are in various languages, oftentimes, and you just go to www.housing.org for the toolkits. There's a reasonable accommodation toolkit, which has samples of the types of letters that you can request from medical personnel. Just want to point out that you can actually get any third party who has information about the disability as to write a letter. There's also a criminal records toolkit. Next slide, please. So there's the information, which is also in the legal resources to forward us in a claim for investigation to our fair housing team. We have a great little team here in Northern California. And as a final note, I'd like you to share to what extent you and your clients may be impacted by the intersection of the various issues we have gone over today. To share in the chat. Okay. Income, discrimination, criminal history, and domestic violence, emotional support animals, income. I'll just let, it's the end of my presentation time, but I'll let you guys kind of look over the chat. Thank you so much for having me.
Avantika, thank you so much for that very informative session or presentation, especially those really helpful toolkits at the end. We are going to do a quick transition here due to time. We're going to shorten this bio break if you are needing to take a break to 3 minutes. And so we'll see you at around 1:49, 1:50. If you are looking to stay on with us for these next few minutes, do check out the chat responses here, as Avantika mentioned. And if you haven't yet been using our Q&A feature, please, we do want to hear from you. Drop in your questions in that Q&A chat box. We want to make sure that those questions don't get lost in the regular chat, and so bring those in. We'll be coming back to those at the end of the presentation. Okay, folks, thank you so much for dropping in those questions, and welcome back if you're returning from break. In this next portion, we will be hearing from Jorge Iniguez, who joins us from Legal Services of Northern California, serving vulnerable populations across the region. He is a proud Sacramento native dedicated to civil rights litigation, union law, bankruptcy law, and climate justice. His presentation will focus on common housing issues and landlord disputes. Jorge, I turn the mic and presentation over to you.
Perfect. Thank you for the warm introduction. I'm going to share my screen so you guys can see the material. Okay. And I think we should be good now. So yeah, just to repeat, my name is Jorge Iniguez. I'm a staff attorney at Legal Services of Northern California. Today's presentation is going to be kind of an overview on tenant protections. We're going to go over a little bit about the issues with habitability, harassment and discrimination. I'm not going to touch up on as much because Invantika just did, but we're going to talk a little bit about AB 1482, which is California's Tenant Protection Act, the just cause protections and the rent increase protections. And then we're going to go and give you guys an overview of the unlawful detainer court process. And as a reminder, this presentation, it's not legal advice, it's just legal information. If something gets like really specific or in the weeds, then it's probably best to contact one of us or another organization that does similar so that you can get specific answers, because sometimes the broad legal principles have all these tiny little exceptions that you need to know about. So with that said, we'll get started. So one tip that we're gonna have is when you see this little light bulb, these are like special notes that we've made. So these are like practical tips so that people can remember their tenants' rights. First big issue is gonna be repair and habitability issues during a tenancy. So this is when the landlord is responsible. So a rental home is legally uninhabitable if it substantially lacks effective waterproofing, weather protection, including windows and doors, plumbing, gas, heating, and electric systems in working order, floors, stairways, and railings in good repair, cleaning and sanitary building and grounds, and working heating system. Now, notice here that there's one item that's not on here, which for folks in Sacramento is probably really important, and that's air conditioning. So technically, the way the legislation is written right now, folks, landlords don't have to provide air conditioning. It's something that we're working on, but they do have to provide heating. And depending on when, let's say, your heating breaks down, there's a different standard for how quickly they have to repair it. So if your heating stops working in the summer, they have more time to fix it. But if your heating stops working in the middle of winter, then there's a quicker timeline by which the landlord would have to respond and fix that. Big tip here is if something goes wrong, if let's say, for example, the weatherproofing is broken, you need to take photos and start documenting what's going on in detail. So you can start building a timeline of things. So a rental home also, on top of what I said earlier, also has to have a working toilet, a wash basin, bathtub, or shower. It's got to have a kitchen with a sink, lighting in every room, or an electrical outlet so that you can get lighting in every room, working deadbolt locks in the main entry door, safe fire or emergency exits leading to a street or hallway, and working smoke and carbon monoxide detectors. On the flip side, right, so we just went over what the landlord's responsible. The tenant is responsible for keeping their home clean and sanitary, use and operate gas, electrical, and plumbing fixtures properly as they're supposed to be used, not to destroy, deface, or damage the property or allow anyone else to, or use their home as a place to live and use rooms for outside of their intended purpose. And if the renter has caused the habitability problems, then the landlord does not have to make the repairs. Of course, important here is always keep a copy of your lease agreement, just because sometimes it'll have the nuance about who's responsible about certain things within here, and always just a good advice overall. So for requesting repairs, let's say something is broken off of the list that we just went through. So you're going to want to tell your landlord by phone or in person, and ideally in writing. And the reason why we want something in writing is because if you do the phone and in person, that's great, and it's really easy to do, but it's really hard to prove that you've done it. But if you have it in writing, it's easier later on to say, okay, you gave them this in writing a month ago, and now it's been a month, they still haven't fixed it. Make sure you're specific about the repairs that you need, right? Don't just say that something is broken. Just say, what thing exactly. And ideally send a letter by certificate of mailing and keep a copy of the letter and your certificate of mailing. And the reason why we're going through all these formalities is that in the end, if it ends up being that there was something substantially wrong with the property and they didn't fix it in time, there is a narrow avenue to be able to later on down, like in an eviction proceedings, argue that the rent is overstated because the property wasn't worth the amount that they were charging. But to be able to do that, you got to show that you had the repair was needed, and you made it in writing, And of course, we're going to talk a little bit about the choice to pay rent or not, which we always think you should, just because we get people, I'm getting a little bit ahead of myself, but we get folks who try to withhold rent because of the repairs. Generally not a good idea, but we'll talk about a little bit more about it. So the landlord has to respond within a reasonable amount of time. In general, law provides around 30 days to respond, but if urgent, right, then it can be quicker. It can be like 24 hours. And they don't have to repair with every single issue that's at home. So like if your carpets are worn out or the paint's dingy, if it doesn't rise to the level that would protect you from eviction, then it might not be something that the landlord has to fix with the home. And like I said before, a big tip is to put the request in writing and to keep a copy of it. Okay, so let's say you asked and you gave them time to fix it and it still isn't fixed. So what are your options? So there's going to be a few. We're going to run through, I think, 5 different scenarios of what happens if they don't fix within a reasonable amount of time. Each of these has its risks and benefits, and knowing these is going to help each specific tenant figure out what's best for them to do. And each case is different, is the tip there. So one thing that they can do is they can call code enforcement or the building department. So code enforcement can inspect the rental home and they can give your landlord a fine for something being broken. If the repair is required, if the repairs required are very serious, they may issue a citation, which can include the building getting red tagged. So this is the issue with this, with calling code enforcement. If you call them, sure, they're going to come check it out. They're going to say, hey, this is wrong. The landlord has to fix it. If it is so bad that the place is, let's say, like, you know, about to crumble, then they're going to reg tag the building and they're going to ask you to get out now. So if that's the case, you could be shooting yourself in the foot, because now suddenly you don't have somewhere to stay because the place that you stayed, code enforcement says, isn't habitable for you at all. If the repairs are less serious though, then, you know, they issue a type of fix-it ticket for the landlord. So it's option number one that you have. Option number two is to repair and deduct. So this is where the tenant fixes and deducts the cost of the repairs from the rent. So first you report to the landlord and you provide them a reasonable time to repair. Then if they fail to do that, okay, you decide you're going to repair and deduct. The repair can't cost more than 1 month's rent. And it can't be used, you can't do this more than once per year. And the tenant can't have caused the damage, as mentioned earlier. And this is only really allowed for serious defects. So for example, it's 40 degrees outside and your only source of heat stops working. And the landlord's not, you know, they're not answering. So you're like, you know what, I'm just gonna buy a heater and replace it. And I'm gonna take the cost off of the rent. But again, see how we're back at step one of like documenting everything, having everything in writing, setting everything up from the beginning so that we can do these later steps. The other option is to withhold rent. Now, this is not an option that we generally advise on. So renters set aside and save the monthly rent instead of paying it. This is where people will often get in trouble too, because they'll say that the place is broken, and it is. They'll go through the step and they decide, I'm going to withhold rent. Okay, they do that. If later on down the line, the landlord does fix it, now you got to quickly pay the rent. And if you spent the rent, or if the rent went to something else, they don't have the rent, then they can be evicted on the basis of non-payment of rent. So this is one of the riskier options that we generally do not recommend. If you were to do it, the defect also has to be so serious that the home is uninhabitable. So it has to be one of the bigger ones. And like I said, you risk eviction there. So make sure to keep the money if you were to do this, because the first thing that's going to happen in the landlord's mind is, oh, they're not paying rent, I'm going to evict them for non-payment of rent, which is one of the just cause reasons that landlords can evict someone for. Other option is to abandon the property. So you move out. This can still come with some of the issues with the previous withholding of rent though, because if, depending on what your lease said, right, you're still going to be liable for the time when your lease says you were supposed to. You can give notice a little bit early, but then between the time that you're out and the notice, you'd still have to pay. And then the other option, the one that we think is generally the best option, of course, specifics will differ, but generally the best option is to sue the landlord for damages in small court claims. So if you weren't able to get it fixed through emailing them and telling them, instead, you can bring the landlord to small court claims. You're limited to $12,500, but basically you can make the argument there that the price that the landlord gave for the unit isn't worth what the unit is, right? The rent is overstated. And so you should be owed back money because you overpaid for the rent. The great thing about doing it here is if you do it this way, you avoid putting yourself in a position where you could get evicted for like the withholding of rent, let's say. And instead, you get to bring the lawsuit when you're ready, when you have time, and kind of like surprise the landlord on their end. So those are the five main options, as I said, all with risks and things to consider. And of course, like we said, we prefer to go to small claims if you can. It's just safer, and you don't need a lawyer to do it. In fact, you're not allowed a lawyer in small claims, so neither will the landlord. So it's you versus them. So if you started documenting everything well and you have your pictures and your writing, then you're in a good spot there for that. I'm gonna just breeze through this one just because Avantika already touched about this, but there are protections from discrimination and harassment. And in California, landlords can't discriminate or harass based on race, color, national origin, ancestry, religion, gender, sex, gender identity, gender expression, sexual orientation, military or veteran status, familiar status, so like families with kids, disability, sources of income, which does include Section 8, genetic information, age, citizenship, primary language, or immigration status. All these are protected classes and landlords can't discriminate against them. And because Avantika touched up on this, I'm going to skip over this part a little bit. But suffice to say, one option you can do is file a discrimination complaint with the Civil Rights Department if you think you're being discriminated against. Okay. Now we're going to talk about the Tenant Protection Acts, including 1482. So 1482 is the law passed in 2019, which is very great for tenants overall because it gave a lot of protections for tenants that weren't there previously. Throughout here and until the rest of the presentation, I'm going to be kind of using the words eviction and unlawful detainer interchangeably. They mean the same thing, so just don't get confused when I say either. So the Tenant Protection Act of 2019, it limits how much a landlord can raise rent, and it provides for just cause evictions. But the protections don't apply to all renters. So it's not going to apply to most single-family homes or apartment buildings that are newer than 15 years old, and the person has to live in the home for at least 12 months to be protected under the law. And if you're not sure, it's best to consult with an attorney to determine if your house, if you're renting, falls under these protections. Generally, you're going to get less protections for folks who are lodgers, who are guests, who are in transitional housing, or have lived there for less than 1 year. And you're going to get way more protections for mobile home parks, housing choice voucher programs, public housing and conventional housing, and housing that's tax credit. Not all housing is protected under AB 1482, but even if you do not fall under the TPA, there are some protections for you under other laws because Sacramento has its own ordinance which closely follows 1482. Now I'm going to talk about just cause protection. So what 1482 essentially made is that it made it so that you can only, if you're a landlord, you can only evict. You're only supposed to be able to evict if you have a just cause reason for it, right? As opposed to like an unfair reason to evict. And so under the law, we're going to go over what the law outlines as just cause protections. So the landlord has to have a legal reason to end a renter's tenancy. The notice of termination has to state the reason. So they can't just say, just because, right? You have to specify specifically what is the reason why they're terminated. The protections do not apply to most single family homes, as I mentioned earlier, and you have to be there for more than 12 months. And like I said earlier, you have to, it's usually best to consult if you're not sure, just because it can get a little bit tricky. The main two groups that we're going to be working here is no fault terminations, which are just cause, which means it's not the fault of the tenant, versus at fault termination for just cause, which I almost like to think of the at fault terminations of just cause as like how to avoid getting evicted. But first, we're going to be looking at the no fault termination. So when you think of the no fault terminations, you can just think of this as stuff that you couldn't have had any effect on. It's the landlord doing their thing. However, it's still considered just cause to terminate. So reasons for no fault termination notices could be like the owner or their immediate family plans to move in. Now for leases entered in or after July 2020, this clause only applies if the renters agreed in writing to the termination or the lease allows the owner to end the lease for this reason. Important to note here is that one of the issues that you sometimes will see is that owners will have this pretextual argument that, oh yeah, my family's going to move in. But they have to show that they're actually going to move in. And so one way that you can fight that is by saying like, okay, are you sure you're going to move in? If you have information that, let's say, for example, the landlord lives in a mansion in Florida, and they're claiming that, oh yeah, they're going to move into this, you know, 1-bedroom apartment in Sacramento. There'd be a higher burden of proof for them to show that they're actually going to move in, and it's not just pretextual to get you out. Another reason for no fault termination that's considered just cause is the owner's complying with an order from a government agency that requires the renter to move out, or the landlord intends to demolish or substantially remodel the home. So important here too is with the standard of substantially remodel, there's a law that's actually that goes into effect, I think April 1st, so in 3 days, where there's a heightened standard to prove what a substantial remodel of the home means. So what that means, for example, for renters is that if the substantial remodel would require permits, then the landlord, if it requires permits, the landlord has to give you those permits to show you that it really is a substantial remodel. And notice that that word substantial is there. It's important because it can't just be any remodel, right? The landlord can't kick out their tenants just because they want to put new tiles on the kitchen. It has to be substantial. It's got to be big. And there's basically there's a factual argument there about whether or not something is or isn't substantial. And then the other option is the landlord will remove the home from the rental market. That's another just cause termination that can happen. And if renters get a just cause no fault termination notice, then they have a right to receive relocation assistance equal to 1 month's rent if they get a no fault termination notice, and the notice must be for 60 days. So if the landlord does try to do one of these where they're saying, hey, I'm removing the market, I'm removing it, or I'm moving in, or I'm substantially remodeling the home, then they have to give 60 days and they have to give notice. And they have to get relocation of equal to 1 month's rent. Now, on the other end of the spectrum is the just cause reasons, which I like to think of, as I said, as how to avoid getting evicted. So these are basically things that you want tenants to avoid ever doing. At the very first at the top of the list is non-payment of rent. So non-payment of rent is a just cause reason for eviction. If a tenant is not paying rent, then the landlord can issue a 3-day notice to pay rent. And if they don't pay back in the time period allowed, then that can be the basis for an eviction. Similarly, a breach of a material lease in a term in the lease. So if the lease says specific things, you know, like certain no overnight guests or something. Actually, that's a bad example because that can get a little bit murky. But if there's something on the lease that says not to do, and then the client is doing that thing, then that can be a reason for just cause termination. Creating a nuisance, creating waste. So like an example is a tenant using their apartment walls as a punching bag. That's just wasting the apartment. Using the home for an unlawful purpose. If the renter refuses to sign a written extension of the lease, if the extension has similar terms and similar length, this is one of those weird ones where it starts getting a little bit murky with exactly how similar the terms are, because if they're not similar enough, then they could refuse. Criminal activity at the rental home, subletting when it's in violation of the lease, refusal to allow the owner to enter the rental home if the landlord gave proper notice for a proper reason, if the renter gave written notice to move out but did not move out, and lastly, if the renter is an employee gets housing through their employment and the employment there ended. So for that last one, imagine that you have someone who works at an apartment complex, and as part of their paycheck, they get a unit in that same complex. So when do these just cause reasons not apply? So the renter's notice to end a periodic tenancy. A renter has to give the same amount of notice to the owner as time between the rent payments, which is usually 30 days. There's some exceptions for renters impacted by domestic violence, sexual assault, and stalking though. Landlords can give notice to end a periodic tenancy for any reason or no reason, so long as it's not a discriminatory reason. And the landlord's supposed to give you 60-day written notice if you've lived in your home for more than a year, and 30-day written notice if you've lived in the home for less than a year. And the owner can issue a 3-day notice if tenant violates one of their responsibilities in the rental agreement, such as non-payment of rent. But the notice is supposed to give them a chance to correct the problem if they can. And I alluded to this earlier, but Sacramento has its own city tenant protection program. It's essentially the same. It's the same rent increase protections as the state law. It's got slightly different just cause protection, and it only applies if you live in the Sacramento city limits. So it's for the city, not the county of Sacramento, just the city. You have to live in your home for at least 12 months to be protected under the law, which is similar to the AB 1482. And in the city's process to enforce protections, it's a little bit more user-friendly and proactive. Does not apply to single-family homes or subsidized housing, however. Next, we're going to talk about rent control protections. So AB 1482 has rent control protections that say that rent can't be, the landlord can't increase the rent by, the landlord can increase the rent by 5% plus the annual increase in inflation, which right now is 9.2%, or 10%. So whichever one is less. So 9.2 versus 10, 9.2 is less. If with inflation it would be 14 versus 10, then 10 is essentially the max there. So, and if this applies, the landlord can only raise your rent twice in a 12-month period. And so it gets a little tricky here, but they can give you 2 notices of increasing the rent within the year, but mathematically over the 12 months, you can't go over the 5% plus annual increase or 10%, whichever one's lower. Let's see. So in a lease term that lasts at least 30 days, the landlord cannot raise the rent during the lease term unless the lease allows for it. The landlord can increase the rent when renewing the lease for another term. With periodic rental agreements or something that's like month to month, the landlord can raise the rent with a written notice. At least 30 days written notice is needed if it's 10% or less, and 90 days notice if the rent increase is greater than 10% of the rent amount. Okay, in this next section, I'm going to just go over a little overview of unlawful detainer, aka the eviction process, just because I think it helps make people a little bit more familiar with how the process goes. So typically it starts with a notice, right? The tenant did, or sometimes didn't, right? Sometimes it's alleged that they did, but it's alleged that they did something wrong. They either didn't pay rent, or they had someone over when they weren't supposed to. They're being wasteful, or they're being like a nuisance in the property, and they'll be served with a notice, and it usually contain a number of days: 3 days, 30 days, 60 days, 90 days. It depends on the reason why. Certain notices are allowed to give less days. And the tenant is going to have until the end of that notice to comply. And afterwards, it doesn't mean they're boom evicted at the end of the 3 days. It means that that notice can become the basis for eviction proceedings against them. So even when the time on your notice expires, the landlord can't take any action to remove you without going through the process. If they try to, that's illegal. So if they give you 3-day notice and then on the 5th day, they're like, hey, I gave you 5 days, you got to go. That's not right. They still have to go through the process to be able to actually get you out. The only time that the only time that you would be officially at the point where they're like, okay, you have to go out, it would be, you'd know, because it'd be the sheriff, there'd be a lockout notice. It wouldn't be the landlord who's asking that. So after you're served with the notice, then you're going to be served with the complaint. So once the notice expires, right, you had 3 days to do it and you didn't do it, the landlord needs to start the formal court proceedings that are called in court unlawful detainer. So when they file for the UD in courts, they'll also need to serve you with a complaint, a summons and complaint. Typically, most people receive a notice of mailing a little bit before the summons and complaint. You can think of the notice of mailing as a sort of warning that the court's saying, hey, we're going to send you something. And then once you get the summons and complaint, it's the actual thing that they alluded to that they were going to send you. When you get the summons and complaint, this is probably one of the most important parts. You have 5 days to respond. And those 5 days don't include weekends, and it doesn't include court holidays. So most of the time, if you received it on a Monday, then you have to reply by next Monday. If you don't reply, then the tenant automatically loses because they default on the case. So even if their defenses aren't good, it's always good to submit a reply and to submit an answer to the UD by the time, because at the very least, even if they are planning on leaving or moving or getting out, it buys them more time. So I always recommend to fill out the answer. And if we're not available to do it, there is a clinic at the Carol Miller Justice Center, which is UD Court in Sacramento, where they can help you file an answer there for free. And this is what a summons typically looks like. You'll notice it'll say filed by the court, and then this case number is scratched off so for privacy, but it'll have a case number there and plaintiff and defendant. So you're going to file your answer, as I said, 5 days. And if you can't reach it, then you go to the UD advisory clinic. And then after that, you want to start getting ready for trial. You want to consider your bottom line before the date of trial. You want to come prepared and be ready to be flexible and prepare your evidence. So step 4 is basically one of the more stressful ones because you got to start really thinking, okay, what do you have to offer? Are you able to make a deal with the landlord? Let's say, for example, that the issue was non-payment of rent because you fell on hard times and you didn't have the rent. Okay, let's say now you fixed it, you have the rent money, you have it all, but the landlord still isn't really like talking to you. At trial, that's where you want to get your money ready and like you want to be not to pay, but just to have and to know, okay, what can I offer? Is it maybe a move out, right? I'm agreeing to move out by a certain time or for a certain amount of money. And then at the same time, you're also preparing your evidence because there's a big possibility that you might go to trial. In court, when folks have their day in court, the worker from the court is called the clerk. They're the ones who are going to check you in. They'll have an opportunity to speak with the landlord and their attorney about a settlement, and most cases end in settlement. Before court actually starts, you go in, they take roll of everyone, and then the judge does a nice little speech and then says, okay, everyone try to make a deal and negotiate because it's easier for them to have everyone negotiate rather than have like the 10 or 12 so different trials. If you don't settle though, because you weren't able to negotiate, then you do go to trial. If at trial you lose, then you're evicted. And after that, it can be as quickly, as a week that you actually have to be out. But if you win, the case is dismissed, but the tenant still owes the rent for the time they lived there, even while the landlord was not accepting rent. So big point there though is just be on time. Imagine that you're going to spend several hours there because you probably will, and bring all your evidence with you if it's your big day in court. When you're agreeing to settle, you need to remember that it's a compromise. So it's going to be something that both sides don't really love. And you need to compare your settlement to your odds at trial. Some possibilities are to pay and stay, perhaps move out, a behavioral stipulation, but your judgment is going to be binding. So never agree to anything that you can't actually do. At trial, if you do go to trial, if you're not able to come up to an agreement, the landlord's going to go first as the plaintiff. They can ask questions, they can ask their witness questions, and then you'll present your case. You can ask your own questions, you can ask your witness questions, and then you can make a closing statement if you want, and if the judge lets you. Also important to remember, the court generally cares about the underlying notice at issue. Other issues such as habitability and retaliation can be overcome by the landlord having another reason to evict, such as non-payment. And the judge is going to be evaluating folks' credibility. So it's good and smart to call everyone, to call the judge your honor. And the last thing is just, it is a little bit of an uneven playing field. I say that because I think folks need to be ready to know that the burden that they have to overcome is and will feel bigger than the burden that the landlord has to overcome, which is why we need to be prepared, need to have our evidence, and need to be ready for what might happen at trial. After the judgment, if the landlord wins, the sheriff posts a notice to vacate with the date and time of when they must vacate by on the door. Client has 5 or more days to move out, and then the sheriff lockout will happen at the time and date of the notice to vacate. If client is still there by the time the notice to vacate happens, then the sheriff will escort them out. If their stuff is still there, it gets complicated, but the landlord can hold the stuff for a reasonable amount of time. It's usually about a week, I think 2 weeks or 18 days. But they also can charge a fee for having the stuff there. And then after a certain amount of time, the landlord is entitled to throw away the stuff. Just lastly, just want to say, if folks can't make rent, then top of the line is to contact 211. If you're in the unincorporated part of Sacramento County, apply for SARA 2. although they're no longer accepting new applications as of December of last year. Continue to update your rental assistance application, inform your landlord in writing that you applied for the rental assistance application. That's important because there's some defenses to an eviction, which include you having applied for rental assistance, and make a plan B in case the rental assistance runs out or is unavailable. And then just a little plug for ourselves, Legal Services of Northern California. We also help with healthcare, Medi-Cal, appeals, grievances, denials of authorization, clean slate expungement, and some criminal records, SSI, SSDI, unemployment, childcare, senior issues, education, name and gender, change petitions, just kind of a broad overview of stuff that can help the community. And if someone needs our assistance, then we, in Sacramento, we recommend they call our number, 916-551-2150, any weekday except for Wednesdays, because Wednesdays we are basically closed for case reviews. And we recommend they call right at 8:30 because we have a queue of folks. We can only take so many, so we have to take the first that come in. We have like kind of a cap that's daily. If you're calling and you get on hold, then we recommend that they just stay on hold. Otherwise, if they call again, they're going to lose their place in line. So that's basically all we did today. Little recap, we went through habitability issues and repair requests, how you do that. Harassment and discrimination, we just did briefly because Avantika talked about that. We talked about the just cause protections under the TPA and the rent increase protections, what's legal and how much you can increase rent by. And then we did sort of an overview of the unlawful detainer court process. And that's it. So thanks for listening, you guys. That's all I have.
Thank you so much, Jorge. And we're gonna be popping up the screen here again. All right, you'll see that. Thank you so much for, again, another set of informative tools and tips there from Jorge. More examples that have come through. For those who don't have questions, please feel free to sign off. We thank you again for joining us here. We do kindly remind you to complete your exit survey, which helps us build better learning experience for you in the future. And watch out for our emails. Coming soon is a training on domestic violence. We saw several of you have had mentioned domestic violence earlier on in this session. So we have another training coming to you. It is a required COC provider training, so watch out for more details. We also have quite a few questions coming through our Q&A, so this is the time to be flagging some of these, and I'll just be running through from top to bottom here, popping in and flagging for Jorge and Avantika. First question here is for disabled in a wheelchair, place on the second floor, elevator ID always out of order. How do we go about asking to be moved or be placed on the first floor? And Avantika, I go to you first.
We have an exact similar case right now. So that would be what's called a reasonable accommodation request based on or what I referred to as an exception. So that is now increasingly subject to a new California law that allows them to request a comparable unit on the first floor. So if you refer that to Project Sentinel, what we would ask for is documentation from a medical provider of the symptoms of the disability, if it's impacting their ability to ambulate or walk or take the elevator or the stairs, or however it actually is working in real life to impair their movement. That would be the main thing that we need in order to request a reasonable accommodation or exception.
Thanks, Avantika. Another question here. Would the housing have to accommodate only if and when an apartment becomes available, or should someone request or need a bottom floor apartment? And then another set here. Would they be required to move someone who does not require a bottom floor apartment to the other apartment as soon as possible?
So to follow up, it sounds like it's a follow-up on that first question about the person on the second floor who needs a request to move to the first floor. So that's now protected. So because that's now protected under California law, and Jorge, maybe you can chime in on this afterwards. I believe that they probably need to put that request as a pretty high priority right now. I don't know if they need to actually move someone though. We have kind of mixed results on that front. They sometimes say, you know, they've got somebody else there. If it's an available unit, then yes.
Jorge, would you like to add on to that?
No, because I'm also just entire the thing that I'm struggling with is whether or not, because the other renter, let's say like the person who just happens to be in the first floor, they also have a rental agreement with the landlord, and so I'm wondering whether or not the rights of the person who need the floor would necessitate that the other person has to leave. My instinct is no, but I think it would be a case by case basis too.
Just running through a few more here. What about when we have a client apply for housing and we do not receive a response regarding their application despite continued efforts to contact the landlord? What can we do as providers?
That's tricky. We do a lot of investigation of databases to find out who we're actually dealing with. There's a widespread scam artists that have infiltrated rental housing markets. So you really need to know who's on the other side of the email and then follow up and see if they can generate an actual document for you to document what they're saying.
Another question here regarding DV. So would domestic violence fall under familial status?
Avantika, you can correct me if I'm wrong, but my understanding is DV by itself is not a familial status.
Right. So can you repeat that question and just maybe I'm misunderstanding what they're saying.
Yeah, so they asked, would domestic violence fall under familial status? And I wonder, we can check our participants and see if this individual is still on the line. And Jody, I see your hand is raised. Go for it.
I have another question when you're complete with this one.
Okay.
So that's an interesting question because we do have a complaint that we filed where we have filed a complaint on the basis of gender, because gender does in the sense that certain populations in terms of women are disproportionately affected by domestic violence, and that's on a disparate impact. It's like a type of a legal claim basis. So it's not like when somebody says, I don't want to rent to you because you're a woman. That's not what they're saying. That's like what we call overt discrimination. But it's more like if a complex is always evicting tenants when they call the police, and the people who are calling the police are the women who are getting disproportionately impacted by intimate partner violence or domestic violence, then that's going to end up in resulting in women disproportionately being evicted from that complex. So if we see something like that, it could be something to investigate. We recently got a complaint from somebody who stated that they are absolutely sure that they're being discriminated against. But when I conducted the investigation and kind of went through the situation, the person actually revealed that the basis of the discrimination was that they're Black, but they actually recognize that the housing complex is actually accepting a lot of Black people to live there. So I said, well, that wouldn't be a type of complaint that would be successful in that circumstances. So really it's a context dependent analysis.
Thank you, Avantika. I see we have a couple more minutes remaining left in the session, but we have quite a few really significant questions coming up here. The first here is regarding discrimination to someone in a protected class. Let's say the tenant application is denied and the property is claiming they're a senior living facility or something similar, but that information was not obvious to the applicant. What kind of proof is needed from the property to show that they are in fact a facility for a specific demographic.
Hmm. So can you state the very first part of the question? So what was the actual information that they got from the senior living facility? They got a denial?
Let's see, the property is claiming they're a senior living facility or something like that. It
So
isn't
those are licensed under the California Department of Social Services. So if I were the advocate, I would check the California Department of Social Services website, find the license. If they are licensed, then you can kind of look online and see if they're like what their type of population that they house. And they usually have, if it's a senior facility, they usually have specified rules over 55, over 62. They are allowed to have those types of bases. However, those types of licensed, what we call normally like a nursing home, they are required to still follow other discrimination laws. So they're not allowed to be discriminating on other bases. And they're also subject to another California specific law called the Unruh Civil Rights Act, which requires for business establishments to not penalize or discriminate against various protected classes. So I would, if you're the advocate working in that circumstance, think that it might be a case that you could refer to us if you find documentation that there's some sort of discrimination happening on a protected class.
Thanks, Ivantika. This one for Jorge, what are the limits on security deposits?
Yeah, so for security deposits, there's actually, I think, a law that goes into effect in 2024. So from now until July 2024, the limit is 2 times the monthly rent, or if it's a furnished unit, it's 3 times the rent. After July 1st, 2024, the limit should be 1 month's rent. There is some exceptions though for landlords who own no more than 2 residential units, and like, you know, they're like a natural person and they're not a limited liability company. But that one only comes into play until July 1st, 2024.
Thanks for that insight, Jorge. Another one here, do requests for accommodations need to be signed by a medical professional?
No. So that's one piece of information that I want to, if anything, take away, that these people can use other social workers, or even people say they go to a 12-step community and there's somebody who's their sponsor. Those people can actually write a verification letter about their disability symptoms. So please let people know that.
Thanks, Ivantika. And Jody, you mentioned earlier that there was a question that came through. Do we still have that question?
The question was around the deposits, so we've already acknowledged those. Thank you so much.
Wonderful, thank you. All right, I see we are a little over time here, but wanted to just check in with our presenters. Would you be willing to say a few more minutes, or we can certainly continue to plan on following up with any unanswered questions and sending those off to include with our follow-up email.
I could stay a little bit longer myself.
Yeah. And I
All
put this in the chat, but I'd just like to say, please be very careful as an advocate, because there is a very big power imbalance in these circumstances. So what they may be entitled to under the law may not be what they actually get.
And Jody, I see that your hand is raised. Go for it.
Yes. So in reviewing the questions that came in when folks were registering, one of the main questions was, is there a housing list for Sacramento County where they can find fair housing approved resources? Is there a list of properties that our providers can direct their clients to?
That's an excellent question. I would just say affordablehousing.com, but that I don't know if other people are finding that helpful. That is a list of Section 8 voucher friendly properties.
I think that's right, because if you even, I was gonna say on shra.org site, it even will link to affordablehousing.com. So I think that might be a good starting spot.
Jorge, can you drop that link in the chat, please?
Yeah, I'll let it.
Thank you so much.
Okay, we'll take a couple more here. What if someone signed a lease and their child was on there, but now they probably the landlords, they say that they aren't on the lease like was told.
I would say get a copy of the lease, because the lease is gonna be binding there, right? And what you want, that's why, like, when you sign the lease, you're supposed to get a copy yourself, keep that copy or take pictures of it, because I know it's easy to lose these documents. But yeah, because that's what's at issue, right? Is whether or not the lease said that. And so one person's gonna say this, the other one's gonna say that. Ultimately, it's gonna be, well, what's written down? So get a copy of the lease.
So for transfer of units, would tenants have to pay the new rent amount for that new unit?
I think you should refer those to an attorney to make sure, but under the new law, they're not supposed to face a rent increase if it's a comparable unit that they transfer to for the disability.
All right, Jody, go for it. See, your hand is raised.
Nope, that was from
Oh.
before. Thank
All
you.
right.
We're all
Okay. Taking a couple more minutes here. Next up is, what advice do you have for landlords that do not want to collaborate with rental assistance programs or accept payments from housing or rental assistance?
Jorge, do you want to chime in?
I don't know, because I don't have a good answer. My answer is don't be a landlord. But I'm not sure. I have to think more.
I can chime in. So about 2 to 3 years ago, California updated the law to include protection if a person has so they're talking about rental assistance in this question. So I think they're meaning Section 8 vouchers or similar vouchers. So we still see widespread discrimination against those people. I believe it's a form of kind of modern day racism, and in terms of like the way landlords say things like professionals only, or they'll even say like it's a form of discrimination, like assuming that a person who's working is actually a better tenant than a person who's relying on some sort of public assistance. But corporate, so we still do a lot of education on that topic. Corporate managers typically have figured this out, that the California law now protects vouchers. What we advise people to do is when they're doing searches for housing, to not present the voucher up front, but just negotiate and ask about, like, what are your available units? Can we get a tour? How much is the rent? What are the requirements? And apply. And then later on down the line, when they say, okay, well, this is the unit available, this is the deposit, and you're kind of in the queue and you're approved, and they say you're approved, at that point, state that you have a voucher. That's now, if they have some sort of problem, like in terms of credit history, there's also new laws coming in California where there's supposed to be a person who has a Section 8 voucher can now provide an alternative rental history. So they may need to work with you as an advocate to say, hey, can you help me provide, for example, a renter's resume in order to document, that you're a good renter, and provide reference letters, things like that. That may be something that an advocate can help them with. But my advice is to try the corporate type places, because they're more up on the law and less interested in getting sued. Just want to share we did favorably resolve a situation where a landlord in Orangevale was refusing to sign a Section 8 voucher for 6 months. And I sent him a cease and desist letter, and he actually changed his tune and signed the paperwork And we were able to get even a financial settlement in that case.
Monica, thank you so much for sharing your insights there, and Jorge, as you're able, we have quite a few of you still on the line, but we are going to follow up with more details in the coming emails. So watch out for that coming through in the next week or so. Want to thank you all for being here with us and learning with us about fair housing. And to Avantika and Jorge, thank you again for your helpful walkthroughs of these different laws and policies as they're evolving over these recent years. Again, thank you again. We will follow up soon. Reach out. You'll also be receiving this presentation deck in that email. And so if you are needing to connect with our presenters or with our SSF team, you'll get those details. Thank you so much. Have a great rest of the day.